To the next class of the intellectual property laws. Let me just reiterate that intellectual property laws are made of three acts. One is the Trademarks Act 1999, which I discussed in the last class. And in this class, I'm going to talk about the Copyright Act of 1957 and the Patents Act of 1970. So two more acts for the intellectual property laws. And I'm doing it from the Bare Act, this particular book. There are only acts given without any notes. So the Copyright Act of 1957, as you see, the first post-independence copyright legislation of India, which protects the work from its unauthorized use. This act provides for the protection of original literary, dramatic, musical and artistic works and cinematograph films and sound recording works. Provisions to Copyright Act are made to protect the expressions, and it does not protect the idea or applicable on ideas. Copyright Act protects the right relating to various different works, which include the right of reproduction of the work, communication of the work to the public, adaptation of the work and translation of the work, all of this. So the Copyright Act of 1957 has 79 sections, as I told you earlier, 79 sections and 15 chapters. Wherein Copyright Office, Appellate Board, powers and procedures of the board, ownership of the copyright and the rights of the owner, rights of the author, different types of copyright work, copyright license, registration of copyright and copyright society's right of broadcasting organization, power of the central government in relation with international copyright, restrictions and governing powers, infringement of copyright and remedies thereto, penalties and provisions to approach superior authorities in the nature of appeal is described and discussed. Further history, objective, scope, applications are as follows. Now, statement of objective and reasons. The existing law relating to copyright is contained in the Copyright Act of 1911 of the United Kingdom, herein referred to as United Kingdom Act, as modified by the Indian Copyright Act of 1914. Apart from the fact that the United Kingdom Act does not fit in with the changed constitutional status of India, it is necessary to enact an independent self-contained law on the subject of copyright in the light of the growing public consciousness of the rights and obligations of authors and in the light of experience gained in the working of the existing laws during the last 40 years. New and advanced means of communication like broadcasting, you have lithophotography, etc., also call for certain amendments in the existing laws. Adequate provision has also to be made for fulfillment of international obligation in the field of copyright, which India might accept. A complete revision of law of copyright therefore seemed inevitable, and the bill attempts such a revision. Second, though the draft bill follows generally in a rearranged form the main principles of the existing law, it has introduced several new features which are briefly indicated below. Number one, a copyright office is sought to be established under the immediate control of the Registrar of Copyrights, who shall act under the superintendence and direction of the central government. The principal function of the Copyright Office will be to maintain, register and copyrights in which may be entered at the option of authors, the names and addresses of the authors and owners of copyright for the time being and other relevant particulars. Such register will easily make available useful information to interested members of public in regard to copyrighted works. In order to encourage registration of copyrights, provision is made that no proceeding regarding infringement of copyright shall be instituted unless copyright is registered in the Copyright Office. In addition to being in charge of the Copyright Office, the duties of the Registrar of the Copyrights will be to entertain and dispose of application for compulsory license and to inquire into complaints and importation of infringing copies. An appeal to the Copyright Board is provided for against the orders of the Registrar of Copyrights. Second, provision is made for setting up a copyright board which will determine the reasonableness of the rates of fees, charges, or royalties claimed by performing rights societies, consider applications for general licenses for public performance of works and all, and will assess compensation payable under the bill in certain circumstances. An appeal will lie to the High Court against the decision of the Copyright Board. Third, the definition of copyright is enlarged to include the exclusive right to communicate work by radio diffusion. Fourth, a cinematograph film will have a separate copyright apart from its various components, namely story, music, etc. Fifth, an author assigning copyright in his work is allowed the option to reacquire the copyright for 7 years, but before 10 years of the assignment, on the condition that he returns the amount received by him at the time of the assignment with interest thereon. The normal term of the copyright is fixed to be the life of the author and a period of 25 years after his death, as against the existing term of the life of the author and a period of 50 years after his death. Shorter terms are fixed for anonymous and pseudonymous works, cinematograph films, mechanical contrivances, photographs, etc. 7. Under the existing law, the sole right to produce a translation of a work first published in India is extinguished after 10 years unless a translation thereof is produced within that period. The draft bill makes the right coextensive with other rights arising out of copyright. 8. Provision is made for the issue of general or special license for public performances of any work by means of a radio receiving set or a mechanical contrivance. A license may be issued to any library to make or cause to be made one copy of any book in which copyright subsists and which is not available for sale. 10. Provision is made for regulating the activities of performing rights societies and also for controlling the fees, charges, or royalties to be collected by them. 11. Certain rights akin to copyright are conferred on broadcasting authorities in respect of programs broadcast by them. 12. International copyright relations, which are based on international treaties, will be regulated by specific orders to be made by the central government. 13. A fair dealing with any work for the purpose of radio summary or judicial proceeding will not hereafter constitute an infringement of copyright. 3. In preparing the bill, the British Copyright Report 1952, the suggestion of the various ministries of the Government of India, the state government, the Indian universities, and certain interested industries and associations who were invited to send their comments on the subject have been taken into consideration. So, well, this is it, and maybe I think I'll do it in the next class. That is the Patents Act of 1970. Otherwise, it's going to become too unwieldy. So, this is the Copyright Act of 1957.